Welcome to the Old Capital Real Estate Investing Podcast with Michael Becker and Paul Peebles. During this program, you will hear interviews with real-life successful investors who will share their stories and provide useful advice on how to acquire, finance, and operate apartment complexes. Now, here they are, Michael Becker and Paul Peebles.
Welcome to the Old Capital Real Estate Investing Podcast. I'm your host, Paul Peebles, National Underwriter for Old Capital, and joining me today, probably the happiest man in the room, because now is the state of Texas open, Mr. Michael Becker?
Sort of, partially open.
So by a stroke of the pen, have you opened up the state of Texas and got people out to restaurants and getting their hair cut, and all the stylists are back in business? And how does that actually work?
The haircut's not open yet, but we have 25% capacity, I think, at most retailers and restaurants. So hopefully, I think that's going to go to 50% capacity here in a couple of weeks, assuming that we don't see a big spike. But I think we're doing pretty good. So hopefully, we're kind of getting back at it. My optimism level is a little bit higher, even though I know we'll probably have a little bit more economic pain before we get to the backside of this, obviously. But I think we're starting to see kind of some green shoots coming out and people getting out, and the weather's a little warmer down here now. It's almost hot. It's almost summer here in Texas, seemingly. So I'm looking a little bit more optimistic than a few weeks ago. Well,
talking about optimism, I think you guys had a good month in collections for April. How does May look right now as we record this, the first full week of May?
A little too early to tell, but generally speaking, we're basically on track to where we were for April at the same time. I do expect we're May 4th as we record this, so I do expect to see some sort of deterioration before it's all said and done, and we'll have a little bit more delinquency probably in May than April. That's my prediction, but I don't think it's going to fall through the floor. So I think we should generally be relatively close to April. At least that's kind of what it looks like, the early indications as of right now.
Well, that sounds good. So as you know, Mr. Michael Becker, who owns thousands of apartment buildings, gives some great inside information about what's going on. So we do appreciate Michael hanging out with us. If you want to get more information about what is going on with multifamily finance, Michael and I and James Eng wrote probably a 17, 18-page white paper report called Multifamily 101. And so go to the Old Capital podcast and download that. That is filled with some great information and some of the updates of what we've seen for Fannie Mae and Freddie Mac, what they've done in the last 45 days or so. So you want to get that information to make sure that you understand about how to underwrite these transactions. So in the podcast today, we have a friend of ours that we've known for a number of years that goes like a lot of people by just one name. So you've heard Cher, you've heard Bono. Well, this is a guy that everyone knows as just his one name called Mauricio. So he is definitely a rock star when it comes to that. So Mauricio Raoul is an attorney. His theme is that he keeps investors out of jail by having them comply with security laws. He takes complex legal matters and puts them in plain English. So on the podcast today, here to scare the shit out of us, it's attorney Mauricio Raoul. Mauricio, how are you?
What a unique intro. Thanks, Paul and Michael. Really appreciate being on the show.
So, Mike, I'm going to turn it over to you, and let's start talking attorney stuff.
Yeah, Mauricio and I have been buddies for, 7 years probably now. I'm trying to think when we first met, probably 2013, 2014, something like that. And spent a few weeks together in the open seas over a few years on the Real Estate Guys radio show. They do the Summit at Sea cruise, so we've done that together. So definitely appreciate you coming on the podcast, Mauricio. Maybe we could start with you just giving a quick little bio background on yourself and kind of tell the listeners what you do for a living.
Yeah, so I'm a syndication lawyer, a syndication attorney. It was just a fancy way of saying I'm an SEC attorney. And my job is I help real estate investors basically raise money to scale their real estate investments. And I just make sure they do it in full compliance with federal and state securities laws. I mean, a lot of people don't realize that when they're raising capital, there's a complex web of things that got to follow. And my job is to sort of help them navigate those landmines and make sure they don't step on any and not end up doing things they don't want to do, like, guaranteeing investor returns, which is what typically happens if you don't do it right.
So before we kind of get into it, we'll talk about some of the things that I think Paul and I have been noticing over the last cycle, some of the things that we fear some people have been doing incorrectly that might get them in some trouble. But before we get into that, maybe talk a little timely and topical subject is, everyone's volume. I know we were kind of bantering back and forth before we started recording. Paul was kind of joking about how, the loan volume's materially down here recently. What are you seeing kind of from an economic standpoint from your world? Because you're kind of on the front edge of these deals. People call you as they're putting them together. What are you observing out in the marketplace right now?
Yeah, I mean, on our front, we've definitely come to, pretty much close to a full stop. There aren't really that many people who are out there acquiring new properties and raising capital from the get-go. I'm not saying there aren't any, but there's certainly a lot less than there used to be. And so we've really spent, the last probably month really helping clients who, I don't want to say got stuck, but essentially we're already in contract and we're trying to close on existing properties and really helping them through that process with our real estate attorneys, just making sure they know what their options are, because there are options out there for our clients, and just making sure that they can navigate the trying to get to the close, which is really the hardest thing in this environment, just because, as you guys know, you're good friends over in the lending world, changing the rules of the game a little bit at the last minute. And so that's obviously caused a lot of issues for clients. And it's just coming up with creative win-wins to make sure that the clients can make it to the finish line. But in terms of new originations, we're using the same terminology as you guys. I mean, we've almost gone down to zero. We've got a couple of people who kind of had started and kind of stopped and started again. But I think everybody's kind of in a pause mode. I'm getting a lot of calls now, people wanting to put funds. So I think a lot of people are kind of looking here in the next, short period of time to put some things together. But I think it's all a trickle down, right? I mean, once the lenders kind of put things on pause because they don't know what's going to happen, then that kind of necessitates everybody else going on pause. So as soon as the lenders start giving us some clarity, or really when they get some clarity, then I think that's when things will start moving a little bit.
Can you talk a little bit about funds and are those rescue capital funds? Are those opportunity funds? Tell us a little bit about, people have been investing in multifamily, that they've been forming these partnerships to go out and acquire properties. And now they're coming to you, groups that are maybe opportunity partnerships looking to build a war chest. Tell us a little bit about, rescue or opportunity funds that you're seeing coming in.
Yeah, so probably before all this happened, 80 to 85% of our clients would be doing what I call deal-specific offerings, meaning they would identify a specific property, they would lock it up, they get into contract, and then go raise the money to go close on the property. So that's what I call a project-specific raise. People were putting together funds back then, but usually, smaller deals or single-family homes or something like that. Since this whole thing happened, I want to say 80% of the phone calls that I have with clients or potential clients have been people wanting to flip that and not go buy a piece of property and go raise for it, but actually get the money in right away so that when they're ready, they've kind of got the cash in the war chest, so to speak, and they've got all their securities compliance done. And so when it's time to pounce, they actually have the money in the bank as opposed to having to just start raising capital. And I think there's definitely some appetite out there for investors, passive investors right now, because obviously people who are in the stock market, haven't had a great experience, even though it's coming back a little bit. I think a lot of them are nervous. And so there's definitely an appetite out there where people recognize that there's going to be or already is blood on the streets, and they see opportunity in the future. Now, how far in the future, who knows, but they see an opportunity. So they want to get their ducks in a row, so to speak, get all the compliance done and to raise capital now so that when they do see that opportunity down the road, they're ready to go and can pounce on that opportunity.
Talk a little bit more about that, just in terms of a bunch of people come together, they've put together monies to go out and purchase a property that may be financed by Fannie Mae or maybe financed by Freddie Mac or maybe financed by a bank or maybe financed by a CMBS loan. And if we can kind of walk through, and maybe I know that the only part of the equation is for you to put together the funding for them to have enough cash to buy into it. But a lot of people are trying to say, well, if there's blood in the street, what does that really mean? Can we actually buy a property from the lender? Do we buy the property from the seller? Do we get a partial interest in the current partnership? So what I'm trying to figure out is, even if they raise the money, how do they put that money to work in a partnership that owns real estate that may have not been so liquid, and now you're bringing in some liquidity into the deal? But are you buying into the partnership? Are you actually buying the asset? Talk to me a little bit about how that money gets put together.
I want to say almost like maybe not an infinite amount of ways you could do it, but certainly let's start with the basics. I mean, there's certainly going to be opportunities where you have people who currently own properties, multifamily, that maybe purchased in the last 12 to 18 months and may have bought, maybe overpaid for the property or relying on near perfect assumptions for them to pull off their business plan. And so now they have a hard time servicing the debt, and they may have to sell, and there may be sort of a forced seller. And so one of the opportunities is to have a fund. So when that seller maybe even doesn't even put it on the market, but somehow you've got a pocket listing, or maybe through a relationship like you guys, they become aware of that they can then basically purchase the property outright from a distressed seller. So that's kind of one way to do it. The other way, of course, is to wait a little bit longer and wait for distressed sellers to basically try and hold on as long as they can and end up losing the properties to the lender, to the bank, and then buy them from the bank. Now, but that takes a while, right? So that unwinding process will take certainly a lot more than a quarter or two. That's probably going to take, I don't know, you guys have a better idea, probably 12 to 18 months or something for those types. Sometimes sellers are distressed and need cash, and as long as they get some cash, it's a pretty good deal. But obviously, if their occupancies and rents have gone down, their economic vacancy, they may be in dire need of cash. So maybe that's an opportunity for the fund to come in and almost be like Warren Buffett back in 2009, where they can provide some liquidity to the project in exchange, honestly, for either equity in the deal. Hey, I'll I'll invest in your project in exchange for 20%, 30%, 50%, whatever it is. Or maybe it's a debt instrument. Maybe it's a loan, just like Uncle Warren did, where they'll just lend you the funds and charge, some interest rate that's agreeable, and maybe they have some options to buy it. So I always tell people when they're syndicating, it's really two different things, right? One is you're raising the capital, and the second is you're deploying it somewhere. And historically, over the last 10 years, people have been deploying it into buying the asset, buying the multifamily. But there's so many things you could do. The other thing that some people are looking into, which makes a lot of sense, again, made a lot of sense back in 2009 and 2010, but with the lending market frozen a little bit right now, and really with a little bit of uncertainty, maybe you can raise a debt fund where you could become the lender, and you can raise a bunch of money so you can then lend maybe to somebody else who wants to buy a property, and you just basically act as the lender yourself. So there's just so many different ways you could do it. But my gut tells me that, and then obviously just to backtrack one more, on the single family front, which obviously is a much smaller amount, it's not the multi, but people may want to go and just put a fund together and go acquire 10, 20, 30, 40 single family homes because they think there's going to be a pullback. And when that happens, they want to be able to pounce. So there's so many options out there. And it's just a question of making sure that we put those parameters in your offering docs. And when you're raising money for something like that versus a project specific, then your business plan is a little bit different, right? You no longer have the pretty pictures of the property and the underwriting for that property and the specific game plan. You have more of what I like to call the parameters. And so you're telling the investors, hey, my plan is to raise this money, and then I'm going to go make the decision as to what to invest in, and here are the kind of the things I'm looking at. And we want to make sure that we put as much of that as we can so the investor knows exactly what you intend to do with the money once I give it to you. But at the end of the day, they're betting on the jockey, right? They're betting on the fund manager because they're not going to have a choice or a say in what you end up putting the money in. So that's kind of one of the bigger differences.
Yeah, that's one of the things that we see quite often is a lot of money that wants to be raised, but trying to figure out how to deploy that cash. Do you put money into a deal that you just put the money in as limited partner and you cram the other limited partners down and you don't become the general partner? And in some cases that you do become the general partner because you've put so much cash into the deal that you've kind of put everybody down to a low enough number that it makes sense. But remember, when you do try to change out the general partner, the captain of the ship, you need permission by the lender if there's a loan that has to be assumed on the deal to change out general partners in that deal. So that's always important. Did a lot of your documents, not the ones that you're doing for these opportunity funds, but the ones that were buying specific properties, did they have a lot of language in there that people would have to raise or could raise funds to keep these properties going as a capital call, or they could accept a loan either from the general partner or loans from the limited partners putting more cash into the deal? How did you phrase some of your language in your original acquisition operating statements and PPMs?
Yeah, those would all be found in the section that it's typically called capital contribution section. It's usually in your operating agreement. In layman's terms, they're called cash calls, but we like to call them sort of additional capital contributions. But typically there's language in there, at least in my documents, where officially step one is, hey, if we need more capital, we may have to come to the investors, to the limited partners, and let them know, and everybody would have to participate proportionally. So if we need an extra, I'm making it up, $300,000, then we would figure out everybody's proportionate ownership, and everybody would have to chip into that. Those are typically not mandatory because most investors who are passive don't want that. They don't want to, if they're going to invest $50,000 or $100,000 as a passive investor, they typically want to know that that's it, that they're not committing anymore or not forced to commit anymore. But clearly, if they don't contribute, then they typically get diluted somehow, and there's different mechanisms. The mechanism I use is if a limited partner is unable to contribute, then somebody else can step into their shoes and basically lend them the money to contribute, and then they're going to have a lien on their shares, so they can pay pretty high interest rates. So there's definitely an incentive for them to pay the cash call if they can. Now I say that's the official first step because a lot of times the sponsor just steps up, even though they may not have a legal obligation to. I mean, I know a lot of seasoned sponsors that if there's some sort of a shortfall, at least in the short term, they just fund it themselves, even though they may not be required to. They don't want to go back to the investors at the beginning, and a lot of times the sponsor will carry that burden if they can. But the first one is definitely the cash call, and then there's always language in there that says, look, if the cash call isn't sufficient, people either don't have the money or don't want to put more money in, then they have the option to go out to either get a loan from a third party or maybe raise additional capital, additional issuances of shares, which of course would be diluting everyone who is in there. And there's of course definitely provisions in there that allow the manager or the sponsor to loan the company money. And usually we have a predetermined interest rate in there. I think it's 10% typically. So if the sponsor wants to loan money to the company, they can do so. And they would be able to get whatever 10%. But my experience is generally sponsors tend to be a little bit nicer than what's required under the law, under the operating agreement, and they'll either take a lower interest rate or like I said, they'll just contribute just to kind of hold it together, and then obviously get paid back when things settle back up.
We talked a little bit about the solutions, about bringing cash to the transaction on current deals. That property may have been acquired and been rehabbed and stabilized 2-3 years ago. Now people are just they may be short on cash. But let's talk a little bit more about the problem. Are you starting to hear from some of your general partners or even some of the limited partners about trying to go into forbearance to raise the capital? What are you hearing these days on some of these transactions that you did 2, 3, 4 years ago?
I don't think we're there yet, Paul, because as we were talking a little bit before the show, or maybe it was at the beginning of the show, it's all about collections, right? I mean, if you can continue to collect what you've been collecting, then it's not an issue. And people have been collecting, a little bit lower, but the month of April was pretty good from all accounts. I saw some people freaking out that they may only have a 50% collection, and it ended up being in that 85, 90%. So that was good. It sounds like May might be a little bit lower, but it's not going to be disastrous. And so the question just becomes what happens in June, July. But obviously, as people are no longer able to pay their rent and that economic vacancy starts going down, your income will go down, and that's when issues come up. And so people have been talking about forbearance, and there's some concern about forbearance regarding their, how is it going to affect their credit, and whether requesting the forbearance, number one, will affect their credit in the future. And number two, really the terms of the forbearance is another issue that's coming up, because if you have to pay, if you get a 3 months forbearance, for example, and you have to pay it all in one lump sum in the month of whatever it is, June or July or whenever it comes due, that probably doesn't help you too much. And the danger with the forbearance is that you've just given yourself a really short fuse. It's almost like getting a really, really short bridge loan, which I know a lot of people were doing that too and probably got caught as well. But I mean, if you get a 3 months forbearance and then you owe 3 months worth of payments in 3 months, and you can't make that payment, then the next step is you're in default, and you're going through that process, and you may end up losing the property. So those are all concerns. My talking, Carrie's a lot more, our real estate attorney is a lot more plugged in with the lenders, but and obviously you guys are too. But my understanding is that the lenders, either you can obviously negotiate anything, and that's one of our big thesis is everything's negotiable. So you can certainly negotiate with the lender to say, hey, look, if we have a forbearance, I don't want you to be reporting that as anything negative on my credit. But the feeling with all the lenders, from what we've understood, is it's going to be similar to 2008, 2009, meaning if you do have some sort of a black mark on your credit during this period, people are going to understand. They're really going to, when you're applying for a new loan in 5 or 6 or 7 years, and they see a forbearance, or you fell behind maybe a little bit during this pandemic, then they're going to take that into account, just like they take into account, bankruptcies that happened during that time, or anything negative that happened in 08, 09, and 2010.
Yeah, forbearance is a default of the mortgage, and that typically, in terms of Fannie Mae and Freddie Mac, you have 12 months to repay it from the period of time that the end of the forbearance is. So you have some time to repay. You don't have to pay at the end of the 90 days. That if you take out 90 days of forbearance. Other part of that is, these are commercial transactions, and you're a sponsor or a guarantor in the deal. So in your personal credit, it's really not going to show up. It's going to show up in the name of the partnership, but that's not going to show up on your personal, credit report or your FICO score. It won't even pull it up on a Fannie Mae or Freddie Mac transaction. Now, if it's a Wells Fargo or a Bank of America loan or a Capital One loan, and it's a term loan with them, it may. That's going to be up to them on what it's going to show up in your personal credit report, but typically it's not, because these are business loans or commercial loans, and so that's really up to them. And the same thing with CMBS; it's not going to show up on your personal credit report. Now, we do say that if you do take the forbearance because there's something functionally wrong with the transaction, income is not there, there's not enough income to pay mortgage debt or pay the vendors or keep the property going, then you're gonna have to take the forbearance. But if you take it, just know what the rules come with. Can we go back to scaring the hell out of people? And I think what I like to try to figure out is, I like to talk a little bit about these money raisers in the past, and professional money raisers, and there's amateur. Professional money raisers are the ones that are SEC licensed, and they have a registered investment advisor, something that's behind their name, and they typically have a broker dealer that's functioning with them. But I'm talking about the amateur money raisers. Can we talk a little bit about that? Because I see that being a problem that's been in the past, that I think where we've seen if we have some of these partnerships that start to fail, it's going to unwind, and the sponsors are going to be caught with a big problem. Can you talk a little bit about that?
Yeah, I couldn't agree with you more. I've been talking about this for quite some time, about a year now, because I've been seeing this practice, developing over the last 2 or 3 years, honestly. I mean, 3 years ago, let's say, you would typically have one sponsor in a deal, and maybe they had a partner. And so you had 2 individuals doing a raise, and that makes sense. And every so often you'd have a third person come in, because maybe you're in a marketplace you're not super familiar with, and somebody's boots on the ground over there, and so you bring in a third person. But that was it. And now you get to the point where you're seeing 4, 5, 6, 10 sponsors on a deal, and the reality is the primary reason some of those, not all, but some of those, what we call co-sponsors, are there for is simply to raise the capital. They're money raisers, and they're getting a percentage of the GP, a percentage of the deal, not for anything they did other than bringing in the capital. And this is why I call my, I've got that ebook about, how to stay out of jail. And not that you're going to end up in jail necessarily, but it's just understanding the seriousness of these securities laws and how complex they are. But most people don't realize that when you raise money for others, including others, meaning your syndication LLC, what we call your issuer, you better either have a broker-dealer license, a FINRA broker-dealer, or some kind of investment advisory license, or you have to find an exemption to that registration, right? It's just the same as when you're raising money and you're looking for that Reg D exemption, you need an exemption. And if you're the actual LLC that's raising the money, what we call the issuer, then obviously you're raising money for your own account. So you don't have to worry about anything. You have what's called an issuer exemption. But if you're the general partner, or if you're a co-manager, if you're a co-sponsor, you don't get the benefit of that issuer exemption. You need to show that you fall into some other type of exemption. Otherwise, you need to register as a broker-dealer. And the gist of it is, if that general partner, and when I say GP, I'm talking when you have 4 or 5, if one of those individuals inside that GP is getting what's called transaction-based compensation, meaning they're getting compensated based on the amount of money they bring in or contingent on whether they bring in money, that is the hallmark of broker-dealer activity. Transaction-based compensation is the hallmark of broker-dealer activity, and so they will be required to register as a broker-dealer, which of course they don't. And so by doing that, they are violating they're violating the broker-dealer laws, which has 2 consequences. One is, well, the person who's bringing in the money is obviously acting without a license. They're basically practicing without a license. So that has those consequences. And the penalties usually are disgorgement, and, you got to get the money back plus penalties or what have you. But I don't necessarily care too much about that. My biggest concern is for my clients who are the issuers of the security, or the legitimate GPs. They don't disclose that, obviously. So whenever you pay somebody compensation and they're a broker-dealer, which is totally fine, then that's a disclosure that you make in the document. So you just say, hey, look, I've hired this person, or I've hired this firm, and they're raising money for us, and we're paying them 6%, 8%, whatever you're paying them. And that's a disclosure that's made. And it makes sense, because think of the passive investor who's investing in your deal. Do you think it matters that whoever recommended that security to you was getting compensated for that, if that affected their, whether they thought it was just a simple introduction or whether this was a good deal or not? And so you have to disclose that. And when they fail to disclose, then you're engaged in an illegal offering, because disclosures are the name of the game. As you know, you're required to disclose all of the material facts, especially if you have non-accredited investors. And so you're going to fail to disclose the fact that this one individual or 2 individuals were basically money raisers, and they were unlicensed, and essentially were paying an unlicensed broker-dealer compensation. And so that's going to be the main issue. And I always thought that this would all be a problem once the market turned, because typically what happens is, if somebody complains, if an investor picks up the phone and makes a complaint, then the SEC or the state regulator opens up an audit and an investigation, and they start talking to everybody, and eventually they'll find out that these people were just money raising. But it actually started happening before this turn, before we hit the pandemic. The SEC has shown an interest and really starting to crack down on that. So even before things were going bad. So I can only imagine, when they
show an interest, what do you mean by showing an interest?
They opened up an investigation. There's at least one investigation out there that we're aware of in our industry, where the SEC is looking into possible violations of this, of a fairly large, syndicate. And, they've been sending out letters to all of the passive investors and everybody, sort of anybody that's affiliated in any form, shape, way, or form with these syndicates. At this point, they're at the stage where they're simply requesting that that these individuals don't destroy any evidence. It's just a letter from the SEC, just like, look, don't delete your emails, don't burn or shred your docs, preserve the evidence, so to speak. And this was all before COVID, so I'm sure things are going to slow down a little bit because of everything going on. But there's clearly an investigation going on, and I guess we'll just wait and see whether these syndicators were violating, and were they really doing real work, because that's really the way around this. The way around this, and when I say around, it sounds nefarious, but the way you become a legitimate co-sponsor is you don't get transaction-based compensation. That's number one, but you have to do real work, and that we call that substantial duties. You have to be doing something other than raising money, and most of your time, and when I say most, I think 50% plus one of your time needs to be focused on those duties, those substantial duties, not on raising money. And so that's what you're going to have to prove. They're going to have to prove that they didn't just get compensated for bringing in investors, that they actually were doing due diligence or asset management or underwriting or, talking to lawyers or managing the manager, whatever they're claiming. They're going to have to prove that. And if they can't, they're going to have some issues.
So a couple of questions, I guess. One, would work being done during the acquisition phase, but maybe not necessarily on an ongoing phase, would that pass the general smell test in your opinion? So say like they did the diligence, help with the diligence, and they helped underwriting the deal, but then necessarily kind of help with the ongoing asset management. Is that fair game, or is that potentially an issue right there?
Unfortunately, it's all what we call facts and circumstances. So each individual, it's all going to be looked at in the individual level. And unfortunately, and this is what I'm really hopeful from this one, is the guidance we've had from the SEC, probably 90% of it is all focused on the transaction-based piece. And so I'm hoping we're going to get a little bit more guidance on what you're really asking, which is what really is substantive? Like, what does it mean to be engaged in substantive activity? Asset management, for sure, is part of that. And really what the SEC is focused on is are they doing anything other than on the capital raising or the syndication piece? I mean, are they involved after all the money's in the door, you've closed on the offering? Are they still around? Are they still doing investor relations or asset management or, whatever it is that they're doing? Or did they go home at that point? Once the raise was done, did they just kind of pack up their bags and go home, and now they're just collecting a paycheck? That's what they're really looking for. And so, but having said that, it's all facts and circumstances. If they were, let me give a good example, if they were the ones that were solely responsible, they were really a great underwriter and they underwrote the deal and the deal was purchased based on that underwriting, and then they went through and did the due diligence and the walkthrough and all that stuff, and in exchange for that, they got paid, 5% or 10% of the deal, that may be okay.
Yeah, but Mike, that's not the way it goes down, because this is the conversation that goes down. Hey, Mauricio. Hey, it's Paul. Hey, Paul. Hey, I like that apartment building that you're sponsoring, and I think I want to invest in it. I have a rich brother-in-law. Can I have him invest in your deal? And can you pay me, $50,000 or a percentage of the deal?
Right.
And that's how that conversation starts.
Oh, sure. No question, right? And then they get paid a certain amount if they raise $500,000 and a different amount if they raise $1 million. So that's obviously, well, I'm sure that's how most of those people go about it. So in your estimation, Mauricio, is it better or worse or equal on who's going to have more potential exposure, whether it's the person illegally raising the money or the sponsor of the deal taking that money into it?
I think the sponsor is the one that has most of the issues. Remember, I think a lot of these, that they're both the money raisers and the sponsor. So I think the person that's actually bringing the capital is got the double whammy, but certainly the person putting this deal together and paying these folks to raise money for them is going to be the issue. And the problem is they're going to end up guaranteeing the investors money. So even if the investors lost money because of the violation of the securities laws, they're going to be responsible for making them whole, plus interest and all that fun stuff, which typically means they end up filing for bankruptcy because they usually don't have the money to cover all the losses.
So if I invested my brother-in-law's money into Mauricio's deal, Mauricio would be ultimately responsible for that if they found out that I was not legal about raising the funds.
Oh, that's the easy one, because that's the transaction-based part of it. So that's very settled law when you do transaction-based. So the referral fee example is a great example. And when you think about it, again, if I ended up investing in your deal because Johnny made the recommendation, and then I found out later that, well, Johnny was getting paid for that recommendation, it definitely affects your view of the investment. So they need to know that. That's a disclosure you need to make, and as the sponsor. And so when you fail to make that disclosure that this person was getting compensated for making the introduction or raising, helping to raise the money, then that becomes a failure to disclose issue, which is a material fact, which means now you've engaged in an illegal offering and you haven't complied with all the rules and regulations, which means now it's basically your fault. And the main remedy, again, is restitution. So even if they lost money because of no fault of your own, you had a pandemic and 50%, you've got a 50% vacancy now because of the pandemic, that's arguably not your fault. But because you didn't do it right and you failed to follow the rules, now you're going to be on the hook for all of that money the investor lost plus interest, which is going to be a tough thing for them to swallow.
Right. So that's the scare the shit out of you scenario, because Mauricio may have, and again, I'm picking on Mauricio, may have raised money correctly if I'm a limited partner and everything was disclosed, but there may have been something that Mauricio failed to do on limited partner number 2 that was brought in by somebody else that got paid on the deal.
Mhm.
And so you're really going to, if you're a limited partner and you have a deal that's failing, just make sure that the rest of the limited partners came in without having a sponsor pay an amateur money raiser in the deal, because you may have one person that came into that partnership the wrong way, and they may screw up your entire partnership. Anything more to add to that, Mauricio?
Not only that, I mean, you will not most likely, you will be barred from raising capital in the future, whether that's a lifetime bar or a 5-year bar or whatever. But you're likely going to be what's now called a bad actor, which if you end up getting tagged with that, then you're going to be barred for life. So now think of it, this is your livelihood, and you raise money, do these syndications for a living, and because you didn't pay attention to the rules and you brought in a couple of money raisers, now you can't do that. You got to go find yourself a job.
What's your take on maybe something slightly different, but a lot of these people I've kind of observed, or at least I believe I've observed them taking people that they don't necessarily have a substantive pre-existing relationship with, and we're doing this under 506B, Reg D 506B versus C. So taking both accredited and non-accredited investors in, and they maybe don't have a pre-existing substantive relationship. They post something maybe on a Facebook group, and someone invests $50K off an advertisement they made on Facebook that was, illegal, or the way I understand it, illegal, the way they go about that. Are you seeing, or do you expect to see the SEC take a little deeper look into these types of activities, or do you think it's just going to be predominantly around the transaction-based compensation?
No, I mean, that's a different issue, but that's also a huge issue. So that is clearly when you don't have that pre-existing relationship with the investor, and you're relying on a 506B, that's going to be a violation of that 506B, which means you can't rely on it, which means you now have an unregistered offering. And so that's going to be an issue as well, just like the money raisers. Now, do I think that the SEC is actively scrolling through your Facebook feed or Instagram feed or LinkedIn feed looking for this? No. I think it's similar. I kind of joke a little bit about this, but I have tinted windows and I have no front license plate. Don't tell anyone, but I never get pulled over for not having a front license plate. But if I get a parking ticket, that gets tacked on. And the same analogy I give to this, I think once investors complain about something else, which is I lost money, then the regulators open up an investigation, they open up a file, and then they're going to look at everything. And they're going to look for, people getting paid without being a broker dealer. They're going to look for advertising that happened on Facebook, because they're going to ask them. They're going to say, hey, John, how did you find out about Mauricio's investment? And then he's like, oh, I saw a Facebook post. I've never met Mauricio, but I saw this great Facebook article or post, and that got me to invest. And it's going to be a 506B, and that's how they're going to find out. So I do think it's going to be an issue. As soon as people start complaining and picking up the phone to complain, just like the money raise, I think those are the two biggest things outside of obviously, you mismanaging and losing investors' money out of your own fault. But arguably, this isn't your fault. You lost investor money because of something outside of your fault. But because you didn't follow these rules, you're going to be on the hook for it anyway.
That's why you need Mauricio and his team to make sure you do not go to jail and you comply with all the security laws. They're there for a purpose. And if you step out of line, they're going to nail you. But so you need somebody like Mauricio. Again, it's just one name, and everybody knows the name Mauricio, like Cher and like Bono, in this space. So spend time with him and kind of understand what he does and how that all works out. Let's just finish it up a little bit. Mike, anything more to add to our conversation here?
No, I think that's I will say I've heard Mauricio beat the drum on this for quite a while now, and it's been really consistent. I've seen him teach and train for many years. So I would echo Paul's sentiment. I think he'd be a great resource for you guys to reach out and try to learn how to do this business the right way. Maybe one little final comment is if you are a syndicator and you did something wrong, like I'm sure there's probably a couple people on this podcast saying, oh shit, like Paul said, listening to it right now, what would you recommend that they do? I guess kind of one, stop doing it going forward, but any other practical, tactical advice to someone that might be in that situation?
It's tough because, obviously stop doing it in the future, but, remember these are securities laws. So the security violation happens at the time that you sold that security, meaning the investor gave you the money. That's the point in time that you're looking at the stuff. And once the cat's out of that proverbial bag, you can't really put it back in there. So if it's happened, it's happened. And, number one, don't just make sure you're working with a securities attorney that just understands all these things. I think people forget that there's so many rules and regulations out there. You may not hear about them most of the time, but a good securities lawyer always has those in the back of their mind. And if it comes up, they'll bring it to your attention. But it's just making sure you don't do it moving forward and understanding what you have been doing. And then honestly, you've got to hope that you can rely on the golden rule defense, essentially, which is, you got away with it and nobody complained and you didn't lose money, and, you live and learn and make sure you don't do it the next one.
I think that's great wisdom. Again, what do you call the investigation the SEC does against you just at the initial point that they try to memorialize everything?
Yeah, they start with an audit. Well, there's two things. They usually start with an audit, so they'll send a letter to the sponsor. But in the case that we were discussing, because there's so many people involved, meaning there's limited partners and there's so many different money raisers or potentially money raisers, that the SEC sent out a letter. It's to make sure they preserve the evidence. It's a preservation of evidence letter that the SEC put out, which is just, there's nothing bad. Just if you got one, it doesn't mean it's the end of the world. It just means, hey, don't destroy anything, because if you do destroy something, then you'll be in hot water. But if you, to the extent you've got, notes and files and pictures and emails or whatever you've got, doodles, make sure you preserve those, because that's what they're looking for, preservation of evidence.
Mauricio, Raul, what's the best way for somebody to get a hold of you if they have some questions or security concerns, or just want to, to develop a relationship with you? Maybe things are not going right now, but they do in the future want to invest in real estate. What's the best way for them to get a hold of you?
I'm more than happy to talk to listeners, so they can always email me at Mauricio, Mauricio, at premierlawgroup.net. Mauricio at premierlawgroup.net. Any questions your listeners have, happy to answer them, happy to hop on a phone call with them and, help out however I can.
Sounds like a plan. So, Mauricio, thanks for being on the podcast. We certainly do appreciate it.
Thanks for listening to the Old Capital Real Estate Investing Podcast. Please join us at oldcapitalpodcast.com to sign up for our weekly email updates. We'll see you next week for another great interview.